So I think we're going to get started, especially since last week we went a little bit over. I'm going to see if we can do our best to keep us on time today. I appreciate everybody and their patience in sticking around with us, and apologize for going over on our time. So we'll start with just a reminder that if you have any questions or comments, please leave them in the chat. And I will do my best to read them and answer them as they come in, or we might just kind of hold them and wait until after the presentation. I'm going to be running Kevin's PowerPoint and watching the chat, so hopefully also my dog is quiet and I don't have to worry about him. But we'll get started now. Assistant Prosecutor Kevin Mayer is going to do a presentation on prosecuting gun cases. Kevin, if you can do a brief introduction and your role in the prosecutor's office, and we'll get rolling.
Yes, good evening, everyone. As stated, my name is Kevin Mayer. I'm an assistant prosecutor here in Summit County. I joined this office 22 years ago, and I've been on several grants. The one I'm currently working with is the gun grant. I am assigned strictly to firearms cases. I review, most of them are homicides. As a matter of fact, just a minute ago, I was prepping for my homicide on Monday. But basically, what this grant consists of, I work closely with the Gun Violence Reduction Task Force, which consists of officers with Akron Police. I work with a federal prosecutor right down the street from us, and we have meetings once a week where we go over the firearms cases that occurred in the previous week in Akron. Every single morning, I get a report from the Akron Police Department that reports to us every single firearm case that occurred the night before. Sometimes they're shootings, sometimes they are just someone was pulled over and a firearm was retrieved in a vehicle. They don't all have to have used the gun, just it's illegal for many people to own guns. And so a great deal of the cases I deal with aren't actually the guns going off, but people having them when they should not have them. During this meeting, we work with the federal prosecutor to pick out, for lack of a better term, the worst of the worst in Akron. If we find an individual who is charged with a gun case, a felony gun case, then the federal prosecutor will look at that person's background, which is very key to their sentencing, what you can get in their sentencings. If they do the math and determine that they can get several years, if they take the case as opposed to if we take the case, then we compare, potential sentences. And if it's determined that they can get more bang for their buck, so to speak, we would defer and allow them to federally prosecute those individuals. We don't give them a lot of cases. I believe in this PowerPoint, it mentions at that point last year, we had somewhere in the lines of 40. I recently received an updated list, and at this point in time, it's actually gone up since the last few weeks, but 89 individuals who were arrested in Summit County, in Akron, just in Akron alone, with firearms, 89 of them went federal. We decided that the feds could get a better conviction or get a better sentence, so we defer to them on those. The remaining cases, which are the bulk of the cases, stay here and they're prosecuted by our department. So I believe there's a presentation that we're presenting. James, if you can go on to the next one. Gun cases, we're going to be going through a list of things. What is a weapon, a firearm versus a handgun? Look, in the Ohio Revised Code, there's a lot of redundancy built in. A handgun can be considered a firearm as well. Not all firearms are handguns, but all handguns are firearms. We're going to go over basic gun control laws, how to prove a gun case with and without forensic evidence, how the prosecutor's office evaluates gun cases and makes sentencing recommendations. Now, those would be the ones we decided to keep. Once we give them to the feds, that's their business. What trends are we seeing involving guns?
I'm so sorry. You said all guns are not firearms, all firearms are handguns?
No.
I'm sorry,
rifle-
I missed that.
Rifles are firearms, but they're not handguns. A handgun will always, by definition, be considered.
Okay. Right, because a handgun is a rifle. I get it. Okay, I misunderstood what you said. I apologize.
Okay, I was just giving you one example in the code. As I said, there's a lot of redundancy built in. Do you know what a dangerous
Right,
ordinance is?
I apologize.
No, that's okay. That's why we're here.
I was a little late coming into the meeting and I apologize.
Well, we're going to start all over again. No, I'm just kidding. I mean, there's firearms, there's handguns, there's dangerous ordnance. Anyone know what a dangerous ordinance is? It's all built into the firearm section. A dangerous ordinance.
What did you say? A dangerous ordinance?
Yeah, dangerous ordinance. It's built into the section with firearms and handguns. You ever hear of a Molotov cocktail?
Yes.
That's a dangerous ordinance, an incendiary
Okay.
device. Shotguns are considered dangerous ordinances. Zip gun, those ones they make in prison, the little guns that go off, those are considered dangerous ordinances. There's a variety of them. Anyway, let's see, gun violence in the community and how crucial it is, how crucial citizen cooperation is. Trust me, I wish we had citizen cooperation on a lot of my cases. That'd make my job a lot easier. And then finally, what do you do if you find a gun or know someone that has a gun? All right, next slide, James. What is a weapon? A firearm? As you can see, any deadly weapon capable of expelling or propelling one or more projectiles by an action of an explosive or combustible propellant. So a BB gun doesn't count because it's not the chemistry. I did teach at Akron U. Were you one of my students? Someone just asked the question. I now teach. Oh, okay. Oh, well, welcome back. I now teach at 2 police academies. I'm not at the undergrad level at this point in time, but I now teach at. So if you ever decide to become a police officer, you might be running into me teaching the legal portion of the police academy. Handguns, any firearm that has a short stack and is designed to be held and fired by the use of a single hand, hence the term handgun. Next slide, please. Basic gun control laws. And trust me, I can go into great detail about our gun laws in Ohio now, and as they changed on June 13th of this year. It's a little complicated, and I hope to touch on that today. I think I'll have the opportunity to go through several things regarding that. As of last year, or always, Ohio was an open carry state. A lot of people may not realize that, but anytime right now, I can sling an AR rifle over my shoulder and just walk down the street. Completely legal because it's out in the open. Concealed handguns.
As long as you don't have any previous felonies, correct?
That is correct. But how do you know I have any previous felonies? If I do have it and the officer has individual knowledge of that, that officer can stop me. But if they just see a guy walking down the street with an AR, a lot of people have done this over the years where they know the law, they know it's legal, and they walk there. Some officers do not and stop them at gunpoint. Completely illegal, unless there's some other issue going on. Officers are allowed to approach people with rifles slung to their shoulders, and they're allowed to have what is known as a consensual encounter with that individual. You see these people every now and then on the news walking down the street saying, I'm just trying to keep my street safe, so I'm going to march up and down the street with my gun. And police are free to go, excuse me, sir, can I talk to you for a minute? Now, when they are doing a consensual encounter, that citizen has the right to go, no, I have nothing to say to you. I'm just going to keep walking. You have a nice day. That's a consensual encounter. There's two other kinds. There's Terry stops and then there's actual arrests. But for the most part, now going back to what you stated earlier, well, what if I have a disqualifying conviction? Not all felonies disqualify you from having a firearm or a handgun or deadly ordnance. But if an officer sees somebody carrying a gun and that officer knows that person has a previous felony conviction for drugs or felonies of violence, if they know that, they're allowed to stop you. And then if they confirm it over the radio, you're now under arrest. So that is to be done at this point. Good. Is my microphone working? Can everyone hear me?
You're good.
Yes, we can hear you.
Okay, there's a little thing keeps popping up saying it's not. So we talked about open. Now we're talking about carrying a concealed weapon. Under the Ohio laws, no person shall knowingly carry or have concealed on the person or concealed ready at hand any of the following: a deadly weapon other than a handgun. And before you say anything, the next one is a handgun other than a dangerous ordinance. And 3 is a dangerous ordinance. So that's the legislature's way of saying, you can't carry any of those. I just saw a question about sex offenses. There is not having a prior sex offense is not a disqualifying event to carry a firearm. I've never had that. Well, unless I take it back. If it's a felony crime of violence, such as a rape, I believe rape technically qualifies as a felony conviction of violence. So I'm going to back up there and say for a rape, yes, that would probably most likely, although I've never had a case of that nature, that would probably put you under the disability as long as rape is defined as a violent offense, which I'm almost 100% certain it is. Lower level sexual offenses, gross sexual impositions, unlawful sexual conduct with a minor, I do not believe those carry with them the disabilities. So, sorry, what? I didn't hear that question.
I don't think it was a question, Kevin. I think you're good.
Okay. And notice if a weapon involves a firearm that is either loaded or ammunition is ready at hand, then the penalty, then that is a felony. We've had people stopped in vehicles and the officers find a firearm, but the firearm's unloaded. However, right near it is the magazine, the part that and the magazine has bullets in it. And I could take the magazine and put it in the gun and make it loaded. That weapon, even though it did not have the magazine in at the moment the officer found it, by definition, it's still considered a loaded weapon because there's ammunition ready at hand. It says here, your pop-up is blocking the middle of the screen.
That's me. Kevin, that's me. That's me. I'm just checking the chat because people are putting thoughts. That's me.
Okay, no problem. All right, next slide, please. Carry conceal license. It's an application process. There's training and education requirements, competency certifications, and a criminal background check. Guess what? You can still do that. Okay, you can still go get your CCL. However, as of June 13th of this year, as long as you are a qualified adult, you no longer have to get that. You can go to a store tonight, buy a handgun, and conceal it in your pocket, loaded. You are, if and only if you are a qualified adult. But the question remains, what is a qualified adult? Can anyone tell me what a qualified adult is? Anyone here a qualified?
Under the influence of drugs or alcohol and no prior felonies with at least 11 years of experience.
Well, you just named two of about 20 things, but you're correct. But it doesn't just cover people under the disability.
Is it true that you can get a CCW after 11 years of no prior felonies?
I don't believe it's 11 years. If you go to
Because
29,
my previous fiance was told that as long as it had been 11 years since his previous felony, that he could get his CCW in the state of Ohio. He was told that at CSB.
I'm going to tell you this. Under the new laws, yes and no. And what I mean by
Fair
yes,
enough.
is under the new law, which I can go into in great detail. It's under 2923.125 D A1 A through J M N O S and Q. Let me break it down for you. A qualified adult.
Specifically, right?
Yeah, specifically. I can tell you this. A qualified adult in the state of Ohio, all it means is if you would have gone to the sheriff's to get a license, a carry conceal license, and if after that long background check, they say you're qualified, if you would have theoretically passed their background check, then congratulations, you are a qualified adult. Okay, but here's the problem. Most people don't know the arduous process the sheriff's office goes through when they do a background check on you. Did you know if you have a prior conviction within the last 10 years of resisting arrest, if you go to the sheriff to get your license, they're going to say, sorry, you don't qualify because you have a prior resisting arrest conviction within the last 10 years. Come back in a year, assuming you were already on year 9 or something of that nature. So the problem here is, how are the cops going to know that? Because if the cops pull you over, they can't run the same exhaustive background check that the sheriff's office can, because the sheriff's office doesn't hand out the licenses right away. They do the background checks. So that is just one example of the one of the qualifiers. If my wife gets a civil protection order against me tomorrow, and she goes through the first hearing, which is ex parte without me, and then a week later or a couple days later, they say, okay, Mr. Mayor, you have the right to come and fight this. And I show up at domestic relations and I say, this is wrong, whatever. But the judge or magistrate says, no, we're going to give her the civil protection order. In other words, she's established that she's in legitimate fear of me. If a CPO is put on me, I am no longer a qualified adult. I can no longer carry under the guise of being a qualified adult. So that is another one. If I've, and there's, like I said, there are several things on that background check that could in fact disqualify you. It is a little redundant, meaning it does copy the weapons under disability section of the code. We talked about that. If I have a prior felony conviction for drugs, either possession or trafficking, it doesn't matter. Or I have a prior felony conviction of violence. It's typically a felonious assault, a robbery, things of that nature. Those disqualify me, and those are mentioned under 2923.125 subsection D. Just to make it easier on you, if you're ever bored and you want to see what the definition of a qualified adult is, you go to 2923.111, and that is the right of a qualifying adult to carry a concealed handgun. It says, as long as you satisfy all the criteria listed in D1, sections A through J, M, P, Q, and S of 2923.25 of the revised code. So that forces you to go to that section and look all those up. If you've previously been in a mental institution, you're not going to be a qualified adult. All right. if you're in the country illegally, I don't know if we still use the term illegal alien, but you are not a qualified adult. If you were discharged from the military on a dishonorable discharge, you are not considered to be a qualified adult. So these are the things that can cause people, even after June 13th. Another thing, let's just say you're a qualified adult. Let's say you would have passed all the background checks and you're a qualified adult. Under the old law, before June 13th of 2022, if you were somebody who had a carry conceal license, a lot of people don't know this, but the state of Ohio, for decades, one group tried to make carry conceal the law. And for decades, it was shot down. Well, the biggest voice, the biggest group that was vocal about not having carry conceal licenses was the FOP. And I get it. They didn't want a lot of people being armed. About 15 years ago, maybe, I can't remember the exact date. They finally got their way. They finally got concealed handguns became legal in the state of Ohio. But they threw a bone to the police. They said, all right, sorry, we allowed this, but however, we're going to put a rule on people having a license. If you pull someone over and that person has a carry conceal permit and they are armed, they must immediately upon contact notify the officer. The officer didn't have to ask. They have to notify him. They have to be proactive and go, officer, I have a carry conceal permit and I do have a firearm on me. That's supposedly to put the police at ease. That was a little extra they gave the cops to make them happy. June 13th, 2022, we became the 23rd state in the union to interpret the Second Amendment as meaning having to get a license from the sheriff's office is not necessary under the Second Amendment. So therefore, they got rid of that requirement. And they said any qualifying adults can go get a gun and hide it on their person without going to the sheriff's office. We became the 23rd state to allow that. And unfortunately for the police, that little additive I told you about having to be proactive and notifying the police upon a stop that you are armed, that's now gone too. However, there is a way to counter that, as I've instructed police. You know how police pull you over and they say, hi, license and registration? Well, they're now adding an additional question. Anyone know what that question is? Hi, license and registration. And do you have
a gun?
Do you have a gun? Yes. And
A weapon.
yeah, or usually it's a firearm or weapon, and Molotov cocktail, whatever. And if you do have a firearm,
they're putting you in cuffs.
ouch, and you lie or you refuse to answer, the code section says, if being asked upon failure to notify, only after being asked, failure to notify that you are armed is an arrestable offense. It's a misdemeanor of the second degree. It's only a misdemeanor, but it's still a crime. So that is what changed in the law, or a part of a change. We had officers called us under the new law the other day and said, hey, I pulled over this woman. She was the passenger in the vehicle, but she owned it. She was working, what is it called? Uber Eats, where she delivers food. The officer asked her if she had a firearm under the new suggestion, and she said no. However, and she would have gotten away with it, but for the fact the officer smelled burning marijuana. I won't bore you with the case law, but if officers smell marijuana in that car, they now have probable cause to search the car for that marijuana, which the officer did. He found an unloaded handgun in the glove box, and behind the seat in her car, it wasn't in the trunk, it would have been better for her, but behind the seat, the passenger seat, the magazine was there with rounds included. So
So with the new law, they don't have to be separate, do they?
Under the new law and old law, it's still considered a loaded firearm.
Right, but you don't have to have them separate anymore with the new
No.
open carry, correct?
As long as you are a qualified adult,
Oh, and because of the weed, it disarmed them, correct?
it's only because of the weed that got them permission to
Okay,
serve.
okay, that's what I just said. Because of the weed, it disqualified them, correct?
Well, maybe federally, but no, having weed is a misdemeanor. That's a misdemeanor. So no, it would not have put them under the disability because the disability requires a
But
conviction
having weed with an open firearm is a felony.
only if you're high. Only if you're high. If you have it in the car, that's not. But I'm going to tell you something funny. I know it gets complicated. Under the federal guidelines,
Lay down.
having a drug of abuse in the vehicle with a firearm is a violation of their rules. But that cop stopping you is not a federal agent. So, and we're not going to arrest them for federal violations. But the feds are on the same page as us. So that's where it gets complicated in the future because you may get you may be considered a qualified adult in Ohio law, but the new Ohio law says, oh, by the way, you have to be in compliance with all the federal laws. And the federal laws are a little different. So that's where it gets a little complicated. So what I'm basically telling you is if you want to confirm, this is just for your information. If you want to confirm that you're a qualified adult, my advice to you would be to go over to section 2923.125 D1 of the Ohio Revised Code and check all those things. Because, oh, and by the way, you still might want to get a license from the sheriffs. We still offer those because if you decide to travel to some other state, some states still require the license from a sheriff's office. So you don't get to drive into another state and go, oh no, I'm a qualified adult. They're going to look at you and go, what the hell is a qualified adult? Not every state has that. So that's all I'm telling you as far as that goes. My advice, and I can talk about this for hours because in fact, I actually go to different police departments and lecture on the new law. But to sum it up, a qualified adult is the equivalent. If you are truly a qualified adult, you are now the equivalent of a person who actually went and got a carry conceal license. That was the change on June 13th of 2022. The only question becomes, are you in fact a qualified adult? All right, next slide. Now, basic gun control laws, privileges and duties. Identification required. Well, not anymore under the new law. There are forbidden carry zones. Okay, even if I'm a qualified adult, guess what? I don't get to carry my hidden handgun into my kid's school. I can't walk into the school. There's also places that put up signs that say, you are not allowed to carry a gun in here. Private businesses are allowed to do that. Now, if you do carry it in violation of that, it's actually just an M4. It's equivalent to a trespass. Because if you come to my house with a gun and I say, you can't bring that in here, you don't get to go to me and go, Second Amendment says I can, I'm walking in. You don't. That's at that point, that's a trespass. Because I set the terms. Private businesses can. Bars, you're allowed to carry a gun in a bar now, if you're a qualified adult. However, there's a caveat to that. If you carry a firearm into a bar, guess what you don't get to do all night? Drink. The moment you put a glass to your mouth and take a sip, you're guilty. You're guilty. But you can carry it unless the bar says no and they have a sign prominently put somewhere. You cannot bring a firearm in there under those circumstances. And there's other forbidden places like courthouses.
But how does one drink make you ineligible?
What's that?
How does one drink make you ineligible?
Because that's
One drink doesn't push you over the limit.
That's where you're confusing carry conceal with DUI. I can, when I was a defense attorney, I used to ask jurors, I go, is it illegal to drink and drive? And the answer is no. I can sip a beer. I can sip one beer, get in my car and drive away. that's the gun rule is different. We don't care. We don't have to prove you're inebriated. You're just not allowed to drink if you're
Okay,
carrying a
fair enough.
firearm. Yeah, yeah. It's just I get your point, but you don't have to prove drunkenness.
So if I'm at my house and I'm drinking and someone breaks into my house, I'm not allowed to shoot them? I'm not allowed to have my gun or no?
I'm
asking, like, I'm asking a legit
now you're
Sorry, I
talking
don't
about.
mean to intrude.
So you're sitting in your house drinking as you're allowed to, and someone breaks into your house.
Yes, and someone goes into my house and I shoot them.
You are absolutely.
Is that legal or not?
It's not illegal. Let me put it to you this way. It's not illegal under the section of having a weapon while intoxicated, because that would be
Okay.
assuming everything's on a case by case basis, assuming you had the self-defense privilege. And I can kill someone in my house and still get charged if they were running away from me and I shot them in the back, because I lost the self-defense privilege there. I still have to prove that there's I'm in danger. So, but if we want to give an exaggerated example, it's late at night, I'm in my kitchen drinking at 2 a.m., God only knows why. There's a dark figure down the hallway. I don't know what harm this person's going to do to me, but they're in my house. Under that limited circumstance I just gave, yes, if you have a firearm nearby, you can shoot them. Now, no prosecutor is going to go, oh, hey, wait a minute, you were using a firearm while intoxicated. Not going to happen. Not going to happen. But I understand what you're saying. I'm just telling you, under those limited circumstances, that's not going to happen. So, and if you leave a gun in your car when you go to a bar and drink, you better not be intoxicated when you get back to your car, because being intoxicated in a car with a gun in it, that's a problem. Does losing the self-defense privilege extend to police officers when suspects are around? Officers cannot shoot people under certain circumstances. Every case is analyzed individually. We have to prove that there was an immediate threat. Officers,
Right.
however, another lecture I can do for hours. Officers have something what is known as qualified immunity, which means as long as they acted reasonably, even if they're mistaken, as long as they acted reasonably at the moment they pulled their trigger, then they're fine. They're fine. But the courts will have to analyze it. They will not do a 20/20 hindsight, meaning they won't say, oh, the person, we found out later the person wasn't armed. Yeah, but we didn't know that at the time we pulled the trigger. Just to give you an example. Okay, so cops can still be charged. I don't know if you remember the case up in Cleveland where a vehicle passing the Justice Center backfired, and it sounded a lot like shots. And so the police gave pursuit. And unfortunately for the people in the vehicle, they did not pull over. They led the police on a high-speed chase all through all through East Cleveland. At some point, when they were cornered, several officers surrounded and fired multiple shots into the vehicle. One officer even went as far as jumping on the hood and shooting in. They lost qualified immunity and went to trial. However, they're treated like any other suspect. They have the right to a trial, the right to have the case proven beyond a reasonable doubt against them. They actually succeeded in that case and were not convicted, but they were still treated just like anyone else. They just lost their qualified immunity, which is actually another issue. A question popped up. I'm sorry. What?
Jalen case, they thought he was armed.
Correct.
Not to bring up a recent case, but they thought he was armed. So they had every right based on the suspect that they thought it was armed, correct?
Correct. Now that still requires by law, anytime there's a police shooting, there still needs to be an investigation. So I understand what you're saying, but they're still being investigated. The BCI still has to analyze the situation and come back with their conclusions.
But based on what you said, any time there's an officer involved shooting, that they feel that they are in threat or in danger, they have the right to fire.
It's not feel.
That right to fire.
Don't use the word feel. Don't use, they will be, everything will be analyzed. The moment they pulled the trigger, everything they knew at the moment they pulled the trigger will be taken into consideration. It doesn't matter that it turns out late. What's that?
I said I got kicked out, sorry.
Oh, no, that's okay. That's okay. I'm saying each one still has to be taken on a case-by-case basis and analyzed. So, I mean, there have been cases where, you know, the officer said, oh, I needed to, but the investigating agency said, nope, you were wrong, and the person gets charged. All over the country, there are individual officers. Look, this is a country of 330 million people. So I guarantee you, at some point in time, something's going to happen where it's going to be determined that the officer did not act reasonably. Now, you brought up a recent case, and we're still waiting on the decision from the BCI. So, and I understand your opinion, but we have to wait for them to come up with what they have to say. And each case is analyzed on an individual basis. So,
Kevin?
yes.
Hey, it's James. I want to make sure also, I appreciate all of the great interaction that we're having, but I also want to make sure that we take people's time into consideration. I want to make sure that we stay focused on your presentation, if that's possible, please. We can maybe have some, you're scheduled until 7 o'clock, so you got about 25 minutes left. We can still do some Q&A, but if we can move forward with your presentation, I appreciate it.
Sure. All right.
Thank you.
Thanks for keeping me on track, because I will talk for hours. Anyway, basic gun control laws, unlawful transaction in weapons. You can't, certain transactions are illegal. If I'm under a disability and I can't own a gun, I'm not allowed to bring my girlfriend, who happens to not be under disabilities. I can't bring her to a gun store and look at a gun and go, ooh, I like that one. Buy that one. And if gun stores are trained, the people working there are trained to look at that and then make a decision, and if they can refuse to sell to the woman if they think it's a straw purchase. She's buying it for the guy. That's an illegal transaction. Improper furnishing of firearms to minors, that kind of speaks for itself. You really, if you give a minor a firearm and they use it, you're in trouble. Underage purchases of firearms or handguns. You have to be 21 to be considered a qualified adult. I realize at age 18, we are legally considered adults, but for purposes of owning a firearm, they are not considered qualified adults until they turn 21.
I have a quick question. I'm so sorry. I hate to interrupt.
That's okay.
I've had situations, I'm a mental health provider, and I didn't realize that. I had a client who had a parent who was teaching him how to shoot, and he was a minor, like 10, 12, and there was an issue with the parenting. Is that a situation where I would need to report that to Children's Services or anything like that if they're teaching kids to fire weapons?
We may have lost Kevin.
Oh, no.
Let me stop the share. I see he still has his Zoom up, but I think we lost him. I will kind of answer that question in my brief knowledge of it. Purchasing a firearm for a minor is what I think the issue is. You can teach a child if you are a hunter or I think you can do that. I'm not sure that it's something you need to worry to talk to Children's Services about or report that, but I'm going to see if I can grab Kevin back. He got we lost him. So let me text him to make sure he's aware. I know he was in the office, so let me see what that is here. Hold on a second. Uh, Yeah, I don't see Kevin. So, well, unfortunately, you're just gonna have to wait a minute or two. I'm gonna go through the chat here. Let me see here. I don't want to. Yeah, the running away part is a difficult and a very fine line when it comes to a regular person or someone who is law enforcement. Just because somebody is running away doesn't mean that the threat is gone. So if you are a homeowner and somebody comes into your home and they threaten you and your life is under duress and threatened, and you bring out a weapon and they run away, that doesn't mean that the threat has gone. It just means something else. There's Kevin. Kevin is coming back on. So we'll give him a second here to get resettled. Kevin, yeah, I don't know what happened, Kevin. You're on mute though. You're on mute. I think it's our fantastic computer system. It's our work computer system. So that happens occasionally.
Crazy.
So anyway, so you're back. The question that where you got cut off was, and if whoever asked it, I apologize. I don't know who asked it, but had to do with potentially a child being taught how to shoot.
Completely legal. I took my kid to the shooting range to do it, and there's other kids there. It's that I don't like the way that's worded, saying furnishing. Furnishing would be if you give him, if a kid used a gun illegally, and you furnished it, that's a different problem. I'm allowed to hand my, I'm allowed to hand a beer to my child as long as it's in the house. I'm not allowed to give it to his friends. That's completely illegal. But I'm allowed to hand my child a beer and let him sip a beer. If I get him drunk, that's child abuse, but they can sip a beer. They're allowed to shoot guns too. I believe out in the country, young ones grow up doing it. But if a child uses a gun in a wrong way and you furnished it to him, that could be a problem. I believe that's what happened to the parents of a young man up in Michigan who went on a shooting spree. I think the guy in Chicago, the parents got shot because he had access to that. So looking up.
Okay, well, let me reshare the screen, Kevin. We can go back to your presentation.
Thank you. So let's see, improper handling of a firearm in a motor vehicle. Now, I did want to add that under the new law, if you have a loaded rifle in your car, like an AR or AK-47, that's still illegal. You can't go, I'm a qualified adult. That's one of the exceptions. You can have a carry conceal. You can have a gun on you. You can have it in the glove box, assuming you're a qualified adult. But if you're going to transport a rifle, you have to take the magazine out. You have to put it in the trunk. It has to be separated. So you have to access it by only leaving the passenger compartment. But if you're a qualified adult, handguns, you can have it completely loaded and on you. Otherwise, it's called improper handling of a firearm in a motor vehicle. That is a felony of the 4th degree. Having a weapon under disability, we kind of touched on that. That's a felony of the 3rd degree. Unfortunately, we get a lot of those in Akron. People are carrying weapons, and it turns out they have prior felony convictions for drugs, prior felony convictions of violence. There's also other ones. If you are currently a fugitive from justice, if you didn't show up for courts and a judge issued a warrant for your arrest, you are now by definition a fugitive from justice. If you get caught a year later, like say an officer pulled you over and they run your name and go, oh, there's a warrant for your arrest, and you have a gun on you, oh, you're under disability because you're a fugitive from justice, and fugitives from justice are not allowed to have firearms. There's another section under weapons under disability that says if you are a drug addict or an alcoholic, chronic, it says the words are actually chronic alcoholic, you have a weapon on you. Even if you're sober at that moment, you're still under disability. Now, I'm going to be honest with you. I've never had one of those cases because quite frankly, they're very, like, what makes someone a chronic alcoholic? If the state can prove that you go to AA every week, does that deem you a chronic alcoholic? I've never seen that. Almost all the weapon under disability cases I get, the person has a prior felony conviction of violence or drugs. We just had one arrest recently. They were a fugitive from justice. I don't know if you remember the case where the individual shot at kids playing basketball in Akron. He didn't show up for his sentencing. He pled guilty and he was out on bond and he didn't show up for his sentencing. And he was arrested months later by the Violent Fugitive Task Force. And when they arrested him, guess what he had? He had a firearm. Now he's got an additional charge. Now he's got the charge of weapon under disability because he was a fugitive from justice. He wasn't convicted yet of any felonies, but he was a fugitive from justice. So now he has to face an additional F3. Next slide, please. How to prove a gun case with and without forensic evidence. Next slide. With forensic evidence, and they're just giving you examples like fingerprints, DNA. That's forensic evidence. I love DNA. And I have a case coming up. There's DNA involved, and it's very helpful. In a murder case, I love DNA. Without forensic evidence, one of the questions I always ask potential jurors, and I'll ask you, is testimony evidence? Who can answer that? Is testimony evidence? It is 100%. It's evidence. If I commit a crime in front of 20 people and I run away and no one finds the weapon and there's no cameras, does that mean I don't get convicted because there's no forensic evidence? No, of course not. 20 people are going to march into court and go, he did it. I was there and I saw him. Officers can testify to what they observe when they come up on a scene. Next slide, please. Forensic evidence examples: fingerprints, trace reports, ballistics. NIBIN is the National Integrated Ballistic Information Network. I use NIBIN all the time. I have shell casings from one scene, and we enter the shell casings into the NIBIN system, and we might get a report back going, hey, whatever gun fired these shell casings also fired the shell casings that was discovered in another shooting. So if we have evidence that shows someone else did that shooting, we have good evidence that they did this one as well. That's what the NIBIN, we're tracing the ballistics, literally the ballistics. DNA, gunshot residue. If I fire a gun and you catch me quick enough and you swab my hand for residue, there's a good chance that residue will be on my hand. Gunshot residue is good evidence. It's not the best in the world. I can go into lengthy details about that, but I won't. Operability, to prove the weapon was deadly, we actually retrieve the weapon, we will have an officer test fire the weapon to prove its operability. Next slide. If you don't have forensic evidence, you might just have the scene itself, the evidence location. The term here is totality of the circumstances. I use that a lot in my closing arguments. I'll say, look, one fact by itself is not enough, but all the facts together, the totality of the circumstances, that gets us to proof beyond a reasonable doubt. You can have evidence location, suspects' actions before, during, and after the encounter. The officer will testify to what they're doing. Are they doing something suspicious? Victims' actions and or statements. Using proper and effective interviewing techniques. Getting people to acknowledge where they were. I was just lecturing on a case where you get someone's fingerprint on a door from a burglary, and we determined that the door was point of entry. And we get a hit on that. Just like the NIBIN, we get a hit and say, hey, that fingerprint belongs to a guy who was arrested 5 years ago. Because when you get arrested, we take your fingerprints. So how do you interview that guy? Well, if it were me, the first thing I'd say to him, I'd find him and go, hey, quick question. This house over here on 123 Main Street, where the break-in occurred. Do you know those people there? Have you ever been there? Now, criminals are going to invariably say, nope, never been there. You just got them. You just got them. Because now you go, well, that's interesting because the point of entry in a burglary had your DNA, your fingerprint on it. If you don't get that information in advance and they prepare for trial, you know what they're going to say? They're going to go, oh, you know what? I was there. I knocked on the door and I looked in and put my hand on the door. And that's how my fingerprint got there. So with proper interviewing techniques, you can catch them. That's just one example. Jail calls. I've been listening to jail calls for 20 years. You wouldn't believe how many people say incriminating things on jail calls, or they try to speak in a code on the jail calls. It's interesting. It's a good technique. I like to use it from time to time. You review suspects' field interviews, the field notes. Sometimes you'll get good information from those as well. Next slide. How prosecutors evaluate gun cases and make sentencing recommendations. That's where I come in. Go to the next slide, please. It's a case-by-case basis. Similar cases should get similar results. Bottom line is this. We have a set policy with gun cases now. If you're under disability and you get caught with a gun, we're going to ask for prison. We don't get it all the time. Most of the judges won't. But if you have a gun, and when I say you're under disability, meaning you had a prior conviction, that makes things a little nervous at that point. Let's see. Do you have to inform inmates that their calls are monitored? The answer is we don't have to, but on the phone call, it says, thank you for using inmate calling solutions. This call may be monitored. This call may be recorded and is subject to monitoring at any time. You are now free to talk. So to answer your question, yes, they're told in advance and they still do it. I know it's crazy. Anyway, with each case, we look at them. If someone had no record, like say some 60-year-old carried a gun, had no record, didn't realize they were violating some law, we typically might give that person a break. But if you have a lengthy criminal background and you have a gun on you, we're going to ask for some time. We're trying. Guns are a huge problem in our society today, and more younger children, more and more younger people have guns while they're out there. We also look at the impact on the victim and the community. If a gun was used in a shooting, our office, the elected official, Sherry Bevan Walsh, she's very victim oriented, and we always listen to what the victims have to say. My murder trial this week, I'm meeting with the family members. Obviously, I can't meet with the victim. I'm meeting with the family members tomorrow to go over the case and to let them know everything that's going to happen. We look at offenders' criminal backgrounds, whether or not that we think they're likely to reoffend. If I get a guy who has a criminal history that stretches back 30 years, they clearly don't care. So I'm going to try to get the most time possible as I can. We just had a case today, just to give you an example of the opposite. Person had no record. They had a firearm in the vehicle. They just bought the vehicle. They claimed they didn't know. We let them plead to a 1 degree less. Instead of going, nope, we need prison. We're not going to do that. I think it's important to exercise a degree of discretion, even when it comes to the serious cases such as firearms. With murders, obviously, we're not asking for probation. We can look at offenders' motivations when they had the firearm and why they had it, what they were going to do with it. If we know, were drugs and alcohol involved, those are factors to be taken into consideration. Was there any genuine remorse or or did they take any responsibility for his or her actions? That's more of a sentencing thing for a judge. The woman I gave you the example of that lied to the police when she said she didn't have a gun, the Uber Eats driver, and they smelled marijuana and they found the gun and charged her. She was bawling. She was in tears. She had absolutely no record. She was a qualified adult, actually, at the time. That's why the officer called me. And I said, well, officer, I'll tell you this, the fact that she lied when you asked, she's actually guilty of a misdemeanor. He didn't charge her with anything yet. He was going to call her and get back to her. And he just wanted to know if he could charge her with anything. After he told me everything, I was like, oh, you might want to give this one a warning, but that's up to you. It's not my case. So she had genuine remorse, and she had absolutely no record. So we're really not out to hammer people in those circumstances. Next slide, please. What trends are we seeing with guns? That's a little, some of these are a bit of an exaggeration. People are really foolish with handguns. I've had unfortunate circumstances where two individuals, one juvie, one adult, stole a gun out of a truck and they were playing with it later in the apartment, and the adult shot and killed his juvenile friend. He did not do it intentionally. We did not charge him with murder. He was charged, however, for accidentally discharging the firearm under those circumstances. Next slide. This is a chart that I get monthly in the gun violence task force unit. This one went up to October. I have an updated one, actually, that went up to September of this year. So you can see they looked at incidences on a month-to-month basis. The first graph is discharging firearms that involve felonious assaults with a firearm or murders with a firearm. You can see the very last one was October of 21. That showed 40, there were 40 different incidences in Akron for firearms were discharged under felonious assaults or murders. The next one is calls for shots fired. Those are where calls were made. There may not have been an arrest because no one knows what happened, but people called in and said, hey, there were shots fired. I don't know. I live in Akron. I don't know if any of you live in Akron. I have, when I lived in my old neighborhood in Akron, I did hear shots. It was not, it wasn't a common thing, but I heard it. That would be an example of, if I called the police, that would be an example of a call for shots fired. So you can see in October of 2021, in 1 month, there were 209 calls for shots fired. And then the final chart, the count of weapons recovered on a month-to-month basis. In October of 2021, 90 weapons were retrieved from the Akron Police Department. That could be as a result of an arrest. They took a firearm out of a vehicle or any other way. They retrieved 90. And you can see the percentage of the changes, the year-to-year changes. It was up at that point in time as far as weapons recovered. The percentage of calls out for shots fired at that point from 2021, from 2020 to 2021 was down 6.5%. And for murders and felonious assaults, a 1 year's difference from 2020 to 2021, it was down a percentage of 9%. I actually have the updated one. I pulled it just a few minutes before we started. In September of 2022, we recovered 64 firearms, and that was down 22% from the previous year at that point in time. With discharging firearms for felonious assaults or murders, we had 53 of those in September of 2022, a percentage of 18.5% lower than it was from the previous year. So you can see that the trend is starting to go down. It really went up during COVID. 2020 was one of our worst years. The shootings, everything seemed to climb. But that's just a chart that I get monthly so we can monitor the situation in Akron. Next slide, please. What trends are we seeing with guns? Specialized prosecutors have helped. This at the end of the year, we looked at the year end difference, and we did put a dent in it. We did put a dent in it. We saw a lessening of murders. More guns were recovered, which was a good thing. And when this particular slide was done last year, we had 59 cases that were referred to federal prosecution. As of right now, it is up to, it's actually a little higher than this because I got this printout a little bit ago. We're up to 89. So it's somewhere in the 90s right now. So that's how many cases the feds decided to take. I can give you some examples because some of them are already done. They went through sentencing. They go by months. They go by how many months you're in prison. One was 125 months in prison for one guy. What guns are recovered and what happens to them? Are they destroyed? To answer that question, the guns that are recovered, it's mostly handguns. There's a few rifle cases. I've seen ARs and I've seen AK-47s. The bulk of them are handguns. And I can tell you this, they are destroyed. As a matter of fact, unless, let me put this little caveat out there. Not all firearms are destroyed. If a firearm was stolen, let's say someone stole my gun and a year later it was used in a shooting and the gun's recovered and it's traced back to me. And I'm like, yeah, that was my gun. I reported it stolen a month ago or last year. Legally, I can get that back because I'm lawfully allowed to have the firearm. So it's considered property of mine. I mean, the only things that are definitely never returned are drugs. Obviously, we destroy drugs. If the gun was owned by the perpetrator, by the felon, that gun will in fact be forfeited and the firearm will be destroyed. It will be melted. We don't turn around and resell them. Even though they're technically legal products, we don't sell them. Let's see. Not all prosecuted cases receive a prison sentence, obviously. It's up to the judge to decide sentencing. We've had people that I argued should have received prison and the judge decided not to. That's up to the individual judges. They have discretion. Where they don't have discretion is when we charge with firearm specifications. In the state of Ohio, if I was to commit a felonious assault and shoot at another person, and let's say I injured him but didn't kill him, I could be charged with felonious assault. If I used a firearm, then the prosecutor's office will typically add what is known as a firearm specification. It just says that Kevin Mayer on such and such a date did use a firearm in the commission of the offense. If I am found guilty by a jury, that's actually a separate verdict. The jury would have to conclude I'm guilty of felonious assault, and then a separate verdict form will say, we also find that the defendant did or did not use a firearm in the commission of the offense. If that is the case, then by law, the judge must impose a mandatory 3-year sentence to be ran consecutively. That 3 years has to go first. Then the judge has to impose at least the minimum I could get on a felonious assault, which would be 2 years. So under those cases, the judge, even if the judge wanted to give me probation, I would have to get at least 5 years as a result of that type of case. Next slide, please. What trends are we seeing? Same amount of guns in circulation, just who possesses them. We have made several attempts to get guns off the street. There was a recent buyback program where people could turn in guns and get money for them. All right. In fact, funny story, gun dealers will hang out in the parking lot of those buybacks. And if they see people with like really nice guns, only they don't know it, they'll go, hey, that buyback's offering 50, I'll give you 100 for it. And the person in the parking lot go, oh, okay, here you go. And they don't realize that the gun's actually worth $1,000. Buybacks are nice, but the problem is when we take those, we destroy those. And someone brought up an interesting point. Well, what if one of those guns was used in a murder? We might not want to destroy that evidence. So it opens up a whole other can of worms. Let's see how guns are being acquired. Sometimes guns are stolen. I can tell you a few of my homicide cases. I have one pending right now that the firearm was stolen. So we looked up the person who it was stolen from, and we try to see a connection. What's the connection between them and the person who had the gun at the time of the shooting? Was this person ever invited to their house? Did they live nearby? And did that victim report it as a burglary? So these are the type of things we have to look at. Next slide, please. Oh, sorry, I think we're almost done. The high capacity magazines, I like when those go federal because they charge more. You can see magazines with extended clips. They can have 30. They have drums that will attach. I mean, it can get crazy. Yeah, you're absolutely right about youth. Young people are getting access to firearms because unfortunately, I am currently prosecuting a juvenile who was bound over. We're trying him as an adult because he had a gun on him, and it's a tragic case. He just shot a guy. He got in a fight, got in an argument, shot the guy 14 times. And the first question is, why was that young man walking around with a gun? He was 17 and he skipped school that day. And, you know, it's getting worse and worse. Next slide, please. How crucial is citizen cooperation? I cannot stress this enough. It is very vital that people cooperate. I have a case right now where, you know, I have multiple lay witnesses. Those are witnesses other than police, and I require, you know, their cooperation. A lot of people don't want to cooperate, and I understand. To be fair, I understand, because at the end of the day, they have to go back to the neighborhood they live in, and they're afraid of retaliation. I will tell you, in my 26 odd years, I've only known one case that ended in a serious retaliation. Other than that, they just called names and things like that. But it theoretically could happen. But we do need citizens desperately. Next slide, please. We can only prove our case. We can only prove our case beyond a reasonable doubt. That's the standard we have. It's a high standard. That's why, like one of my upcoming trials, I have 21 witnesses showing up. You know, I don't want to leave any stone unturned. I got to call. I got to make sure we have everything we need. Next slide. Gun violence speaks for itself in the community. It's crucial for citizen cooperation. There's just too much of it. I've had way too many mothers sitting in a chair across from me crying because they lost a son. And it's not going to end anytime soon, unfortunately. Next slide. Gun violence is crucial. Citizens are scared and apprehensive, fear of retaliation. I just talked about that. Like I said, the officers leave, but the citizens have to remain. I get that fear, but we need your help. We need people's help. One time I had a witness who would not come in. They just refused to bring their family member in. So I called the victim's mother, who went to the same church as them. She made one phone call. And an hour later, that person who wouldn't cooperate called and said, "What time do you want me in?" I never forgot that. Because as powerful as I am, it took the mother of the victim to do it. Next slide. If you ever see a gun, don't touch it. Please call the police. We need to document it. If you know someone who has a gun and they're dangerous, please contact someone immediately. I have to wonder how many shootings could have been prevented, but for, you know, someone not stepping forward and doing that. Next slide. I think I'm out of time. I just talked about this. If you find a gun, leave it alone. If you know someone who has a gun and shouldn't have it, don't report people who are qualified adults. But if you have some concern, some red flags, mental illness, you're probably better off telling the police. Next slide. I already said that part. Next slide, please. Here's the number you can call. It could be anonymous. If you don't want anyone to know, you can call and leave it anonymously. 375-2745. That's our gun violence unit. Those are the people I work with on a weekly basis. Next slide. No, goes without saying. Are there any questions? I apologize if I went over. I can talk for hours. about this. This is what I do. But if you do have any questions that come up in your mind later, I'm not hard to find. Except next week I'll be in trial all week. So
Mike, can you do me a favor? Email me what your trial is so I'm aware of it, please. That'd be great.
oh yeah, I was going to do that this week. I get it.
We got time. Well, I appreciate it. Thank you, Kevin, and thank you everybody for the great interaction that we had throughout that. It is 7:10, so I want to move along quickly. We have our next presenter ready to go. Heaven DiMartino is an assistant prosecutor in our appeals division. Hi, Heaven. If you can do me a favor and kind of introduce yourself with a quick, explainer of how long you've worked with in the office and what you do, and we'll get to your presentation.
Sarah's like, bye.
Hi, Kevin. So I'm Heaven DiMartino. I work in the appellate division. I've been with the Summit County Prosecutor's Office for just about 20 years now. I started in the Child Support Enforcement Agency, transferred to juvenile, where I did child protection unit cases as well as delinquency cases. I've done some adult criminal trials. And now I've been in the appellate division for over 10 years, and I handle half of all of the appeals in Summit County at the felony level, from rape, robbery, murder to death penalty cases in the Ohio Supreme Court, half of all the delinquency and half of all of the child's protection unit appeals. So done a little bit of everything with the office. I'm going to talk to you specifically tonight about the appeals process and what we do in Summit County to make sure that all of our citizens' rights are protected, and that we make sure that offenders are held accountable and that our victims' rights are preserved. So the appeals process, I'll talk a little bit about the structure of the Ohio judicial system. So the Constitution of Ohio separates state government into 3 branches, which each has its own distinct area of responsibility. The executive branch, which administers the laws. The legislative branch makes the laws, and then the judicial branch, which interprets and evaluates the laws. So the prosecutor's office is in the executive branch, but we obviously work closely with all the other divisions. So I know Kevin was talking about his federal cases and how some of those gun cases are taken by the feds and they have a completely different system. So this diagram here just is to show you that there are 2 systems in the state of Ohio. We've got and all across the US. So we've got our state courts and our federal courts. I'm going to talk to you about the right side here. So the state trial courts, of course, I'll talk about Ohio, the municipal courts, courts of common pleas. We've got intermediate appellate courts and the state Supreme Courts, the Ohio Supreme Court. And sometimes folks at least try to bring their case to the Supreme Court of the United States, which is the law of the land. But it is really difficult to get the Supreme Court to hear a case that comes through the state system. So I'm not going to talk that much about the federal system unless there's a specific question. So moving along to the judicial branch, like I said, the primary function is to fairly and impartially settle disputes according to the law. And again, that's from the Constitution. So you're going to keep hearing throughout the Citizens Academy. And I thank you so much for partaking in this wonderful program that the office offers, because it is really important for citizens to know all the things that the prosecutor's office does, which is not just going to court, especially on criminal cases, I think is what most people think of, but there's so much more that we do at the prosecutor's office. So on the next slide, it'll talk about the Ohio judicial system, which our trial courts are what impacts most citizens on a daily basis. If they have an interaction with the court, it's usually at the trial court. So municipal court and court of common pleas for each of the 88 counties in Ohio. So if you got in a traffic ticket, if you got divorced, if you had a custody issue with one of your children, maybe you had to fight an insurance claim after a car accident. So those are all things that happen in our trial courts. Then kind of decreasing in numbers, folks would have maybe an interaction at the Court of Appeals if there was an error at the trial court level. So we have 12 districts. They hear cases in 3-judge panels. They review the judgment of the trial courts, so municipal like Akron, Barberton, Stowe, or the county courts like Summit County Court of Common Pleas, as well as domestic relations court, and then juvenile court and probate court. So our juvenile court is over on Dan Street. Domestic relations and probate court are in the same area as the Court of Common Pleas. So they're different divisions. And then Ohio Supreme Court, which was our highest appeals court in the state of Ohio. That's your Chief Justice and 6 justices, but their cases are mostly discretionary. So they can decide if they want to hear the case or if they don't want to hear the case. So to get it, especially a criminal matter before the Ohio Supreme Court, we have to show the court that there's a constitutional question or something that is of great public interest or great general interest, and it's likely to repeat. And in that case, they might accept the appeal. They have to take all the death penalty cases, though. So any death penalty case where we get a conviction and the death penalty is imposed, that direct appeal goes directly to the Ohio Supreme Court. So on the next slide, it talks about the Court of Appeals and, the General Division. And I kind of went too quick because I know I'm short on time, thanks to Kevin. We teach together at the Police Academy too, and we do the same thing to each other. So I apologize for that. Our General Division, a Court of Common Pleas. So if you go downtown and you see the courthouse with the lions out front, that's the Court of Common Pleas. Next door, where you see the eternal flame for the police department, that's our Akron Municipal Court. So our General Division, a Court of Common Pleas, here's all the felonies. So anything you could go to prison for as a crime, and then any civil case where the dispute is more than $15,000. Domestic Relations Court is inside the Court of Common Pleas, and they deal with dissolutions, divorces, spousal support, allocating parental rights. Our Juvenile Division, like I said earlier, is over on Dan Street. Judge Linda Teodosio is the judge over there. She has a number of magistrates, and they hear all the cases that involve children under the age of 18 who committed what would be a crime. So we call that delinquency in Ohio, or a status offense, which is something that you're just not allowed to do because of your age. So smoking or skipping school. But they also hear paternity cases. They hear our dependency, neglect, abuse cases. They hear non-support cases. If there's already an open case over there and someone's not paying child support, that case would be held at juvenile court. If an adult is contributing to the delinquency of a minor, that case also is, the jurisdiction is over there at juvenile court. And if you don't send your kids to school when you're supposed to, failure to send cases are also handled over there at juvenile court. And then probate, which is in our Court of Common Pleas. On the first floor, that's where you go for some good things like marriage licenses and adoption proceedings, but they also handle, as folks get older, you know, we might have mental competency issues, adult protective service cases. They also do some eminent domain cases. So now we can go to the Court of Common Pleas. So that's our intermediate appeals court. And for some reason, I see Judge Sutton's picture has bumped up to the top too. So she's on there twice, but that's fine. So we have 5 judges right now. We're going to have obviously some change coming up with another election, and Judge Callahan not running again. So they hear all the appeals from our intermediate appellate. They are intermediate appellate courts. They hear the common pleas, municipal court, county court appeals. They have original jurisdiction to hear our extraordinary writs. So those are things that you might hear, like a writ of habeas corpus, mandamus, a writ of procedendo, a writ of prohibition, or a quo warranto. And those are, we call them extraordinary writs. They're filed to ask basically a court to do something or not to do something. They're completely separate from an appeal. We hear our cases at the appeals court in a 3-judge panel. Each of our districts has their own panels. In the 9th district, so we're in Summit County, those cases are heard before the 9th District Court of Appeals. So these 5 judges would be the judges that could be on the panel. 3 would be selected. That's for Lorain, Medina, Summit, and Wayne County. So on the next slide, it talks about the Ohio Supreme Court, which is where you would appeal a 9th District decision. And that's our Chief Justice and 6 justices. And obviously we've got an election coming up to replace our Chief Justice. So right now, the Supreme Court is Chief Justice Maureen O'Connor and Justices Kennedy, Fisher, DeWine, Donnelly, Stewart, and Bruner. But they're the court of last resort in Ohio. They are the last place you can get unless you can get to the U.S. Supreme Court, which is very difficult. But in Ohio, that's the last place you can go to have an error looked at. And most of those cases are discretionary. So you're asking the court to please take a look at this, but they don't have to, unless, like I said, it's a certain type of case or a death penalty. If there is a conflict between 2 appellate districts, the Ohio Supreme Court has to take it. So if the 9th district where we are says a rule of law is X, and the 8th district in Cuyahoga County says the rule of law is Y, that's a direct conflict. And the appeals court would certify the conflict, and then the Ohio Supreme Court would clarify that conflict and tell us what the actual rule is. You can go to the next slide. So during the appellate process, someone files an appeal. So that's going to be called the appellant or the petitioner, and they're asking for a higher court to review the decision of the trial court. And the other side would be the appellee or the respondent. So most of the time, I am the appellee. So the defendant is asking the court to find an error. They're filing the appeal. Every once in a while, though, the state files an appeal because we feel the judge made an error that has caused all of our evidence to be excluded and we can't go forward. But most of the time, it's the defendant asking for their conviction to be reviewed or the sentence. In juvenile court, the Court of Appeals can look at findings of delinquency, legal custody decisions, permanent custody decisions, and things that deal with adjudications of like dependency, neglect, abuse, and the disposition relating to that. You can go to that next slide. So the direct appeal. A direct appeal is that first appeal that you get from your felony conviction at the ninth. So go to the Ninth District Court of Appeals. So like I said, delinquency cases, also direct appeal to the Ninth District Court of Appeals. A direct appeal in a death penalty case, however, is heard by the Ohio Supreme Court. So as he flips the slide, I'll tell you that a direct appeal is taken as a matter of right. So I don't have to ask permission. I am entitled to that direct appeal. So the Court of Appeals has to look at it and has to determine if there was an error and how it should be fixed. So James, you can go 2 slides. One more. So the appellate procedure. So basically your appeal starts as soon as you file what's called a notice of appeal, and you have 30 days from the sentencing date to file that notice of appeal. And that's letting the trial court know I'm appealing that decision. You also ask for a docketing statement and a precipice to the court reporter for the transcript. So the transcript of the proceeding isn't automatically made. You have to ask for it. There's a cost involved unless there's a waiver of the cost. But long story short, you have to prove everything to the Court of Appeals. You have to give them the evidence you want them to review. So you need to have a transcript. If you file an appeal without a transcript, there's very few instances where you would be able to succeed because you're giving the Court of Appeals no evidence to support your argument. Once they have all of the documents that need to be prepared, so the notice of appeal, docketing statement, and the precipice, then we get to the point where we're briefing. So we're filing a document, we have a page limit, we're writing our issues, we're applying the law to the facts, and we're asking for a result. So the appellant does that, the appellee does that, and then we either have an argument or we ask the court to decide the case on the briefs. So the next slide talks about the fact that the appellant's brief is due first, then the state is usually the appellee. I would file my brief. The appellant might file a reply brief. They only have 10 days to do that. If they're late, the court generally does not take it. And then you have an oral argument if you choose to do so before that 3-judge panel, or you waive it and they decide your case based on what you've briefed. Some cases on the next slide talks about the accelerated docket. So there's sometimes cases which we want to move along. And those cases, you can leave it on this slide for a second. The accelerated docket is for things like permanent custody cases. So something we know this case could take for a year for a decision, but we want to move this one along because kids are involved, their life is involved. We don't know where they're going to live. So we'll put it on the accelerated docket. But generally, these briefs and our arguments are limited to what happened in the record at the trial court. No new evidence. You don't get a second trial. This isn't a second bite at the apple. It is a review of what happened below. So if it doesn't get in the record, it doesn't happen. It's like it was never there. So even if you have a really good argument, you cannot succeed on appeal if it's not in the record. You might have to try something like post-conviction relief. You can go to the next slide, James. Actually, you can go right through that because I went through that one. And appellate court decisions, this slide is like I was saying, it could take up to a year for a case to be decided after the argument. Sometimes they come out really fast. I've had them come out in a week. I've had them come out more than a year. It just depends on the issue. So the next slide talks about what the Court of Appeals can do, which is affirm, reverse, or reverse and remand. So affirm means they say everything was fine. Reverse means nope, undo what happened below. And reverse and remand is send it back with some instructions. So maybe there's a new trial, maybe a journal entry has to be corrected or something. After the Court of Appeals decision, the next slide there, after it's affirmed, they may try to go to the Ohio Supreme Court. So if you try to go to the Ohio Supreme Court, you're going to have a really good argument in your memorandum because they do not have to take every case. So you can go to that next slide. You do have 45 days, very small window there too, to file your appeals with the Ohio Supreme Court. Again, if they certify a conflict, then they're going to take the case. If it's a death penalty, they're going to take that case. So the next one there, they talk about, so somebody asked, why do some cases take so long? So they don't usually tell us why they took the amount of time they take to decide a decision. Sometimes though, there's a similar issue on appeal in the Ohio Supreme Court, and they might be waiting for a decision to come out. They may just have an issue that's very difficult, and they may be trying to get a majority opinion. So, you know, if those 3 judges don't all agree, you know, they have to get at least 2 of them to agree for there to be a majority decision. You could always have a dissent or a concurring opinion. But some cases, just the issues are very difficult and it takes a lot longer to decide. Some things, there are very well settled areas of law, and somebody's maybe trying to get a small extension of something that's been long decided, and the court can decide that issue much quicker. But some things just for whatever reason are very tough to get all of the judges to agree on, and those cases tend to take much, much longer. So appealing from the appellate court to the Ohio Supreme Court, again, no appeal of right. If the court denies jurisdiction, you just get a one-liner that says we decline jurisdiction. You can go to the next one there. I think that should be delayed appeals. I talked about that, so you can skip that. Delayed appeals, you can do this also in the 9th District Court of Appeals, as long as you don't miss your, deadlines. If you file something late, but you have a good reason, there is a opportunity to apply for a delayed appeal, but it's limited instances. So most of the time at the appellate court, we're very driven by deadlines, and there's not a lot of forgiveness if you miss one. And then I'll just tell you, typically on appeal, we see issues like manifest weight. So they'll say, when you weigh all the evidence, it really isn't supporting a conviction, or sufficiency of the evidence. State really didn't quite prove each element. Sometimes we see more novel arguments and more complex arguments. You can skip to the next slide, which is a lot of the times the cases that take longer. The other cases that take a long time too are going to be things that were, like I would anticipate a case where I have multiple cases that are consolidated. So let's say one person did a number of different crimes over different dates and places, and they're all tried together. That's going to take a long time for the Court of Appeals just to get through the record and to read the transcript and all the pre-trials. So some things are just very voluminous and time consuming. We also see sometimes error that's just, it's harmless. It's wrong, but it's not going to cause a prejudicial effect to the defendant. So the Court of Appeals says, yeah, that was a mistake, but it's harmless. So it's not going to be a reversal, but hey, let's do better the next time. But we always make sure that the rights of the defendant have been protected. If there's been prejudicial error, it is reversible. The next slide talks about post-conviction. Post-conviction relief is something that's separate from a direct appeal. So you have a different time frame. You have a year to file it, and now you can file successive ones. So you can file a post-conviction, then you can file another one. But it's basically looking at new evidence, not the record below. So some mistake by the trial attorney or something that is not in the transcript that you have some evidence of. So you have to attach an affidavit to your post-conviction relief petition and show what that evidence is, even if it's at least an affidavit. But it's new evidence and it's separate from the appeal. So I think that's my last slide. So I think I gave you, Appeals 101 in about 15 minutes. So if you have any questions, I'm happy to take them now, or if you get them, to the office through the chat or something, I can answer them then too. But I don't want to keep you too long. So were there any questions for me in the chat? I was trying to keep an eye, but I don't think I did that great on the chat.
You did
Keeping
great,
track.
Evan. Thank you. I'm blown away by the fact that you did an Appeals 101 presentation in 20 minutes.
New York speed.
Wow, very impressive. I hope that it was beneficial for everyone and that everybody understood. And if we have questions, wonderful. There is a question that popped in.
So yeah, our appeals court judges are elected. So if you are living in Summit County right now and you are going to vote, which I hope you are all going to vote, You will see that on the ballot, you have several Court of Appeals judges up for election, as well as one of the Common Pleas Court judges. I think municipal court judges are up next year, but they are sometimes appointed, but then they have to run for reelection.
And we have not only the Court of Appeals and the Summit County Court, but the Ohio Supreme Court, as Heaven mentioned.
true.
We are electing a new Chief Justice. Among those people, I believe, are one current Supreme Court Justice, Jennifer Bruner.
Yes.
She's on the Supreme Court. She's running for Chief Justice. And her opponent, Heaven, I'm trying to think of what her opponent is currently.
I know, I just draw a total blank, but they
Yeah,
are
me
all
too.
elected. Yeah, if I Google it, it will come right up, but
Yes.
yeah, but there are Supreme Court justices up as well. The next year we'll have our municipal court judges. Certain ones will be up next year too. But yeah, if you're appointed by the governor, you still have to then run for an election depending on at what time you were appointed. But the answer is really they are elected.
For instance, in the Summit County Court system, Judge Amy Corgle Jones, who was involved with a number of high-profile cases, she stepped down from the bench in August to do a number of different things, to work for the Oriana House and be a
Court TV.
Court TV correspondent. So the governor appointed, I believe, a temporary. No, they just
He
have a
didn't.
guest.
So
That's
he
right.
could have
Right.
appointed. He chose
Right,
not
right.
to because of probably because of the short window.
Right.
That was one of the reasons why he did not have to, but he chose not to. So we have two people that are running for that, a Democrat and a Republican that will run, and then someone will be elected, and then they will have to run again to keep that seat, an next election cycle. So yeah,
So
very
anyway, all right,
short
well,
race.
Yeah, very short. So that's really it. Again, if anybody has any questions, that would be wonderful. If not,
Thank you for
Heaven,
having me. It's a
thank
pleasure.
you.
I'm sorry I don't get to meet all of you, but I'm glad that you're doing this. Again, we really appreciate your participation.
And I have 7:31, and I think for the first time, thanks to Heaven, we are wrapping up almost on time. A minute over, 2 minutes over. So again, I appreciate everybody's time. Thank you for taking the time out this evening. If you have any questions, you can email us. If not, then we will see you next week, Wednesday. Have a great night, everyone.
Take care.
Thanks. Bye.